The New York Yankees baseball team of the late 1920s was famous for its so-called Murderer's Row, a lineup of batters consisting of Combs, Koenig, Ruth, Gehrig, Musial, and Lazzari, all future Hall of Famers who dominated opposing pitchers. Our law review here at the Joseph F. Rice University of South Carolina School of Law has assembled what I consider to be an intellectual and legal equivalent of Murderer's Row. And it is my honor to introduce today's keynote speaker, Erwin Chemerinsky, Dean of the University of California, Berkeley School of Law, and unquestionably our nation's leading constitutional scholar. Don't just take my word for it. The publication National Jurist recently named him, quote, the most influential person in legal education in the United States. He's the author of more than 200 law review articles and 22 books. One of those books, simply entitled Federal Jurisdiction, is on the desk of every federal judge I know. Here's my well-worn copy. Dean Chemerinsky is a regular speaker at our periodic judges' workshops, and each year he regales us with his encyclopedic knowledge of the Supreme Court decisions of the past year. When he's on the program, I always go down early and get a seat on the front row. As you might have surmised by now, I'm a huge fan. In addition to his teaching and writing, Dean Chemerinsky also writes op-ed papers for most national newspapers, as well as the ABA Journal, and he frequently argues appellate cases, including cases in the United States Supreme Court. I want to commend Dean Hubbard, our law review, Grace Phillips and her law review members for planning this program on such a timely topic. And I know I speak for all of us assembled here today when I thank Erwin, who, by the way, receives literally hundreds of speaking invitations per year, flying all the way across the country to be with us today as our leadoff batter. Please join me in welcoming a true legal giant, Dean Erwin Chemerinsky.
Good morning. Judge Anderson, thank you so much for that incredibly kind introduction. It's truly a great pleasure to be with you. I want to thank Grace Phillips and the Law Review for inviting me. I want to thank Dean Hubbard for arranging for this symposium and his wonderful, gracious hospitality. When I became a law professor in the 1980s, I had many classes, constitutional law in law school and my undergraduates in federal courts, where for the first day I would have the students read a copy of the United States Constitution and of the Soviet Constitution. I'd also have them read a description from Solzhenitsyn of life in the gulags. My students were always surprised to see that the Soviet Constitution had a much more detailed statement of rights than the United States Constitution did. Of course, the question then is, how could there then be the oppression that Solzhenitsyn described in the gulags? And the answer that I wanted to see from the first day of the semester was that the difference between the United States and the Soviet Union wasn't the words on the paper, but it was in the United States there were courts that could declare invalid government actions, but no court in the Soviet Union had that power. In 1998, I had the very kind invitation to go speak at a conference on judicial independence that was held in Moscow. And it was an international conference with lawyers and judges from across the world. On the second day of the conference, at breakfast, a Russian judge came up to me. He brought an interpreter with him, since I don't speak Russian and he didn't speak English. And his question to me was, how do you remove judges in the United States? I began with a complicated answer of, well, in federal court it takes impeachment, in state court there's elected judges. And it was obvious he was very impatient with me. He says, I want to know, how do you remove judges in the United States? And I essentially focused on the federal model and said, it's a very difficult procedure. It's hardly ever occurred in American history. And then he said, in Russia, if you don't do what the government likes, they just remove you from being a judge. I begin with all of this by saying that judicial independence isn't incidental to a constitutional democracy. It is truly the guardrails of a constitutional democracy. I also begin by saying that I've never been as afraid, or imagine myself being as afraid, for the future of American democracy as I am right now. This is not just a political statement about the moment. I finished a book manuscript in the summer of 2023, came out in the summer of 2024, a few months before the election, titled "No Democracy Lasts Forever: How the Constitution Threatens the United States." It began with those words, "No democracies last forever." We're all familiar with countries that once were democracies, but are no longer. It would just be hubris to believe that there's something in the United States that makes us immune from those pressures. And there is, inevitably, the need to talk about what's going on at this moment. I know that some support the policies of the president, some oppose the policies of the president. I'm not here to discuss the politics or desirability of those policies. But I do believe we are seeing at this moment an attack on the judiciary unlike any before in American history. We have a president who obviously does not feel constrained by the Constitution or laws. Lest you think this is just a statement of a law professor from California, the chief of staff to the president, Susie Wiles, said in November he believes he can do anything, literally anything. What will be the guardrails of democracy that curtail what this president or any president can do? It has to be the independent judiciary. In talking with you this morning, I'd like to make 4 points. First, I want to talk about what is judicial independence. Second, I want to talk about why does judicial independence matter. Third, I want to discuss what are the current threats to judicial independence. And fourth, I want to offer some tentative suggestions of things that we might do to help preserve the independence of the judiciary. As the first question, it's always interesting when we talk about judicial independence to focus on independent from what? Because the judiciary is no more independent of the other branches of government than they are independent from one another. Our Constitution at the federal level sets up interdependent branches of government, interlocking powers. I think part of the genius of the Constitution that's often overlooked and has been too much compromised is it's meant to require that 2 branches of government be involved for any major action. To adopt a law takes an action of Congress, but also the president is involved. To enforce a law requires that the executive bring a prosecution, but the courts then hear the case and decide whether to convict. I can go on with all of the things in the Constitution that envisioned the 2 branches of government be involved. And while there are interdependent powers, there are certainly powers that each branch of government possesses as its unique prerogatives. And so when we talk about judicial independence, I think we're focusing both on the idea of decisional independence and also of institutional independence. Decisional independence is simply that each judge should be able to decide every case by that judge's best view of the law and the facts. Anything that would compromise the ability of the judge to decide the case solely based on the law and the facts is lessening judicial independence. There's also the institutional independence of the judiciary. It is ensuring that the judiciary has the resources and powers to fill its constitutional responsibility. We've seen attacks on both decisional and institutional independence throughout American history. And speaking of institutional independence, I always point out to my students the beginning of constitutional law when we cover Marbury versus Madison, that after lawsuits were filed challenging what the Jefferson administration had done, especially removing federal court of appeal judges in violation of the Constitution, Congress simply abolished the 1802 term of the Supreme Court. That's right. Congress simply said that the United States Supreme Court would not meet or hear cases for the time. That's why, even though Marbury didn't get his commission in March of 1801, the case wasn't heard and decided until 1803. Could you imagine today Congress saying the Supreme Court won't have an October 2026 term? We'd immediately say that's unconstitutional. It's unconstitutional because it undermines, in a profound way, the institutional independence of the Article III judiciary. There's a proposal a few years ago in Kansas to defund the state courts. The Kansas legislature was angry that the Kansas Supreme Court had ruled that there had to be efforts made for educational equity to lessen the disparity in school funding among the schools in that state. And so legislators in Kansas threatened they would simply eliminate the funding of the courts in retaliation. Obviously, doing so. I don't think I'm touching anything. Maybe it's some external force giving emphasis to my words. But that too would obviously be a threat to institutional independence. Decisional independence and institutional independence are interrelated. I think the literature on judicial independence too often treats them as distinct. Obviously, the threat to eliminate funding for a court would have an effect on judges as they decide cases in the future. Also, when you think of things that have done in the past, you can see how they implicate both decisional and institutional independence. In 1936, President Franklin Roosevelt proposed expanding the size of the Supreme Court in response to the decisions that had struck down New Deal programs. There's nothing in the Constitution about the size of the Supreme Court. It's set by federal statute. It's varied between 5 and 10 over the course of American history. But I think that there's little doubt that Roosevelt's threat of court packing caused one justice, Owen Roberts, to change his mind. And in landmark cases early in 1937, the Supreme Court overruled 40 years of jurisprudence. I think that the threat of court packing there did implicate both the decisional independence on the Supreme Court and its institutional independence. I do not think we can talk about what is judicial independence without also putting on the table another concept, and that's judicial accountability. We cannot talk about an independent judiciary without also assuring that there's an accountable judiciary. To go back to when I teach Marbury versus Madison at the beginning of constitutional law, I always ask my students, if we're going to give the courts the enormous power to strike down legislative and executive acts, how are we going to check the judges? And this is something that we struggle with throughout American history. Article 3 accomplished this by promising judges life tenure and salaries that can't be reduced. But what if judges stay on the bench beyond when they're capable to perform the tasks? What if judges act in an arbitrary and capricious manner? Do we have enough ways to hold those judges accountable? In 40-some states, there's electoral accountability of judges, and that's how we hold judges accountable. But judicial elections really serve that purpose. When voters go to the polls, do they really know about the people they're voting for or against? Can they evaluate the candidates? Otto Kaus, who served on the California Supreme Court with great distinction for many years, said that judicial elections for a judge are like you have a crocodile in your bathtub. You would never forget it's there. Many studies have compared state Supreme Courts in death penalty cases, whether the judges are elected or immune from election. and show that there's much higher reversal rates in states where judges don't face electoral accountability. Judges who face electoral accountability are much less likely to reverse death sentences. It certainly shows the effect of that form of accountability. So I think my talk throughout this day of this wonderful symposium, it's important that we keep in mind the interrelationship of judicial independence and judicial accountability. Let me focus on the second question that I posed. Why care about judicial independence? Maybe the answer is obvious, but I still think it's important to talk about. I think in answer to this question, we got to focus on why have courts and why care about the judiciary? But to answer that question, we have to go to another. Why have a constitution? Whether it's a constitution of the United States or a constitution of a state like South Carolina. Here too, let me start by talking about how I began my constitutional law class. And again, with whether I'm teaching my law students or my undergraduates. I always begin with this question. Why have a constitution? What makes the Constitution different from all other laws? And the answer, of course, I want my students to see is that the Constitution is much more difficult to change than any other law. Any ordinance adopted by the City of Columbia, South Carolina, can be changed by the future City Council. Any statute adopted by the South Carolina legislature can be changed by a future session, or even that session. But change the United States Constitution is a tremendously cumbersome process. It takes 2/3 of both houses of Congress and 3/4 of the states. The Constitution has been amended only 27 times since 1787, and 10 of those were in 1791. Since then, 2 of them were to create and repeal prohibition. So the question, I think, for my students and for all of us in this day, why should a nation that sees itself as a democracy be constituted under a document that's so difficult to change? No one alive today was part of approving it. Most of us didn't have ancestors in the country at the time. We can't assume that the failure to change it is implying acceptance of it. It's too difficult to change. And of course, the answer that I want my students to see from the beginning of constitutional law is that a choice was made to put our most precious values, separation of powers, federalism, individual liberties, to the 14th Amendment, equal protection, in a document that's difficult to change. It's to make sure that our short-term passions don't cause us to lose sight of our long-term commitments. This is the essence of what a constitution is all about. It's core to the very concept of the rule of law. I like to explain this by invoking Homer's Ulysses in the story of the Odyssey. And you might remember here that part of it involves a siren who had a beautiful song that would lure sailors to the rocky shoals and cause the boat to crash. And Ulysses tied himself to the mast and had his sailors put wax in their ears so he could hear the siren's song without the boat crashing. I think this is what the Constitution is all about. We as a society tie our hands so as to make sure that we don't crash and we don't lose sight of our long-term values. Well, I think this then explains the role of the judiciary. What's going to make sure that our hands stay tied? How are we going to enforce those long-term commitments? This is the role of the courts. I think in this way, Marbury versus Madison got it exactly right, where Chief Justice John Marshall said, the Constitution is meant to limit government. How will those limits be enforced other than through the judiciary? The concept of judicial independence traces to the earliest part of American history. The Declaration of Independence, this year we'll celebrate its 250th anniversary, enumerates grievances against the king, among them how the king would remove judges and have judges just serve at his pleasure. It is why Article 3 of the Constitution went very far in the direction of judicial independence, assuring federal judges life tenure and salaries that couldn't be reduced. In Federalist number 78, Alexander Hamilton spoke of how judicial independence is essential to a constitutional democracy. Where is it found? Well, in the Constitution, I think you find it in separation of powers, and you find it in the concept of due process of law. The Constitution creates in Article 3 an independent judiciary, and the provisions that I just mentioned are all about trying to assure decisional independence as well as institutional independence. But I also think that judicial independence is required by due process of law, found, of course, in both the 5th and 14th Amendments. To have judges who are not independent, judges who could easily be removed, judges who can be swayed by things other than the facts and the law, means that we're not providing individuals the protections against the deprivations of life, liberty, and property that are constitutionally required. And the Supreme Court has made this clear on many occasions. You might remember a case from about 15 years ago, Caperton versus Massey Coal. It involved a trial court having made a judgment against a large coal company in West Virginia. And then there was an appeal to the West Virginia Supreme Court. The executives at Massey Coal spent $3 million to get their preferred candidate, Brent Benjamin, elected to the West Virginia Supreme Court. It was all the money that was spent in this election. And it succeeded. And then the question was, did it violate due process of law to have Brent Benjamin ruling and deciding the case? And the United States Supreme Court ruled in favor of the challengers, saying that an independent judiciary is effectively a core part of due process of law. Or another example from a decade ago, Williams versus Pennsylvania. An individual as district attorney approved the death penalty being sought against an individual. When he ran for the Pennsylvania Supreme Court, one of the things that he championed is that he had approved the death penalty in this case. The defendant in that case then came to the Pennsylvania Supreme Court with his case on appeal. And the question was, did it violate due process to have that individual participate as a justice on the Pennsylvania Supreme Court? And the United States Supreme Court said yes. In fact, the United States Supreme Court was explicit that due process of law requires that there be an independent judiciary. Dean Hubbard, in his remarks, just spoke of the rule of law. I believe that the essence of the rule of law is that no one, literally no one, is above the law. But how can we possibly ensure that except by having an independent judiciary? The idea of judicial independence is found in many other sources as well. Every state in its constitution assures judicial independence. Due process is a separate protection under state constitutions guarantees this. Here in South Carolina, Rule 50 of the Rules of Professional Conduct for Judges speaks explicitly of judicial independence being a core responsibility of the judiciary. Well, let me move then to my third question, and that's, what are the current threats to judicial independence? There's no doubt the reason we're here today, the reason the South Carolina Law Review has convened this symposium is because of concern over these threats. And there are many that I want to talk about. Let me start with what I regard as most important: the violence and threats of violence against judges. Joan Lefkoe is a United States District Court judge in Chicago. Her husband and her mother were killed when a disgruntled litigant came to her house, came to kill Judge Lefkoe, who wasn't home, killed her husband and her mother. Esther Salas is a judge in New Jersey. Her 20-year-old son was killed when a disgruntled litigant came there. We know that after the Supreme Court's decision in Dobbs versus Jackson's Health, a person was found with a gun near Justice Brett Kavanaugh's home, an individual who has since been convicted. Last year, according to the United States Marshals, there were 546 credible threats against federal judges. There have been a number of instances in recent years in states, Wisconsin, Washington, Indiana, of state court judges being killed. And one thing that has tremendously increased in recent years is the threats that judges are receiving. Judges who hand down unpopular rulings are literally being deluged with death threats against them and their families. Judge John Kuhnauer has been a federal judge in Seattle for 45 years. He said that if he were younger and still had a family at home, he would think twice about wanting to remain on the bench in light of the death threats that he received. He was the first federal judge in the country to strike down President Trump's executive order with regard to birthright citizenship. He was then deluged with death threats. I do not think that we can overestimate the effect that this has on judges and their families. I had the experience a couple of years ago of a protest in my backyard that went viral. My wife and I, as a result, received dozens of death threats. It is unsettling in a way that words cannot describe. Think about what it means for judges who are regularly receiving these. A second threat to judicial independence, interrelated, is the intimidation that judges are receiving. And I'm speaking here beyond the threats of violence, but efforts to intimidate. Again, I can give many examples of what we've seen. There is the swatting of judges. This means that people call anonymously to the police in a way that causes SWAT teams to be sent to the judge's house. Many documented instances of this. There's the doxing of judges, putting online the home addresses of judges when they hand down unpopular rulings. I'm sure you've read of the sending of pizza to judges' houses. Michelle Childs, who's now in the United States Court of Appeals for the District of Columbia Circuit, having been a district court judge in this state, talks about the number of instances in which pizzas that she did not order being sent to her house. And they're often sent in the name of Judge Salas' son, the judge whose son was killed by an intruder. The impeachment efforts against federal judges when they hand down unpopular rulings. In the last year, 6 impeachment resolutions have been introduced against federal judges when they struck down Trump administration actions. It's not that these were introduced because the members of Congress that did so thought there was any realistic chance that the House would vote articles of impeachment or the Senate would move them. There is, thankfully, no history in this country of impeaching moving judges because we disagree with their rulings. The impeachment resolutions were all about intimidation. The rhetoric being directed to judges is about intimidation. We have never seen rhetoric, even like the last week, in all of American history. I'm sure you saw last Friday, after the Supreme Court 6-3 struck down President Trump's tariffs, his lashing out at the judges, saying such things as, quote, their families should be ashamed of them, that they are, quote, unpatriotic, that they are betraying the United States Constitution. Never in American history has a president spoken of the judiciary in that way. And it has an effect in how people think of courts and of the respect that our country has for the judiciary. And again, it seems to me so much of it is about intimidation of judges. Also, when we talk about the threat to the judiciary, we have to consider what's been done to law firms. The bar is inherently interconnected with the judiciary. So if lawyers are intimidated, judges aren't going to be able to perform their constitutional duties. And this is something we've seen in a way, again, unprecedented in American history. Let me talk a bit about it and why I discuss it here in a conversation about judicial independence. Last spring, President Trump issued an executive order against the law firm of Perkins Coie. The executive order said that all of the lawyers in Perkins Coie would have their security clearances revoked. The order said that no lawyers in Perkins Coie could go into any federal building, which would also include a federal courthouse. The executive order said that the federal government would not contract with any clients represented by Perkins Coie. If that executive order was allowed to stand, Perkins Coie could not continue to exist as a law firm. No law firm could operate under those sanctions. So of course you have to ask, what did it do that justified this draconian set of punishments? The executive order is explicit. It says that Perkins Coie represented Hillary Clinton in 2016. This was quickly followed by executive orders similarly targeting other law firms. The law firms of Wilmer Hale and Jenner and Block were targeted. The sanctions were the same. What it did was respectively employ Robert Mueller or lawyers who worked for Robert Mueller. Then the law firm of Sussman Godfrey was targeted. Same sanctions. What had it done? Well, it had successfully sued Fox News, a case that settled for over $700 million. All four of these law firms sued in federal court. 4 different federal judges heard the matter. All 4 judges, and some were conservative, some were liberal, said that this is unprecedented in American history. It's inconsistent with the First Amendment, that lawyers should not be punished for the clients they represent or the lawful zealous advocacy. The judges talked about this undermines the Sixth Amendment right to counsel. And yet 9 other law firms that were targeted did not choose to sue, but settled and promised almost $1 billion to President Trump's causes. An amicus brief was organized to support the law firms. Don Varelli, the former Solicitor General, now at Munger Tolles, organized that law firm, that amicus brief. Over 500 law firms signed the amicus brief, but none of what are regarded as the 20 most profitable law firms in the country signed on to that amicus brief. In fact, when you look at the advocacy, none of those law firms have been involved in bringing challenges to the Trump administration actions. The intimidation is working. We can't separate the bench from the bar, and the intimidation of the bar is so much a separate threat to judicial independence. Talking about threats to judicial independence, I've so far mostly focused on the federal courts, but we have to also talk about threats that are unique to the state courts. As I mentioned, over 40 states have some form of electoral accountability of judges. I believe that electoral accountability is here to stay. We could certainly discuss whether it's a good thing or a bad thing to have elected judges, but I don't see the people voting themselves out of having the authority to choose and review judges. So the concern that I want to focus on is the effect of money with regard to judicial elections. The cost of judicial elections has increased exponentially. I recently had a conversation with a judge in another state, and she said to me, a frequent topic of conversation in the judge's lunchroom is which law firms are most likely to spend money on behalf of the judge's re-election campaigns. And she said, it makes me very uncomfortable to then have to go and sit on the bench and have those judges appearing before me. We're now talking about to run a campaign, millions of dollars needing to be raised for an election or even a retention election. Where does that money come from? It comes from those who have interest before the judges. It comes from the lawyers who appear before the judges. I was involved as a lawyer in a case not very long ago that had facts remarkably like Caperton versus Massey Cole. A jury in Illinois had issued a judgment against State Farm for $1 billion and directing that cars be repaired with inferior parts. State Farm, through a series of subterfuges, through what we'd call dark money, spent a great deal of money to get somebody elected to the Illinois Supreme Court. And when the case was heard in the Illinois Supreme Court, it was a 3-2 decision to reverse the judgment against State Farm, with the judge that State Farm had engineered being put on the bench casting the deciding vote. State Farm initially denied any responsibility in this, but then over time evidence came to light of how it had orchestrated it. A lawsuit was brought against State Farm under the federal RICO statute, and it settled on the eve of trial. This, Caperton, are not the exceptional cases. Money in politics can always be corrosive, but it's especially so when we talk about this in the context of judicial elections. My hope is that the United States Supreme Court will modify the usual rules when it comes to campaign finance for state judicial elections. Going back to Berkeley versus Vallejo, the Supreme Court has said that there's a First Amendment right to spend unlimited amounts of money in independent expenditures to candidate elected or defeated. In Citizens United versus Federal Election Commission in 2010, the Supreme Court said that corporations have the right to do so. I think what the Supreme Court should say is there is a compelling government interest in treating judicial elections differently, allowing not only contribution, but also expenditure limits with regard to judicial elections. I think the Supreme Court has recognized the problems with regard to fundraising in judicial elections. You might remember a Supreme Court case from a number of years ago, and this was William Julie versus Florida State Bar. It involved the constitutionality of the provision of the Code of Judicial Ethics that says that candidates for judicial office can't personally solicit or receive funds. The Supreme Court, in an opinion by Chief Justice Roberts, upheld that provision. And I then think that Williams Julie can provide the basis for the Supreme Court going even further in allowing states to regulate spending in judicial elections in a way that wouldn't be allowed with regard to other kinds of campaigns. So having traced for you some of what I see as the problems with regard to judicial independence and the threats on it today, let me talk about some of what I see as necessary solutions with regard to this. And I think there are many things that we need to do. First is public education. In preparing to come here today and to write the paper for the South Carolina Law Review, I looked at the literature with regard to judicial independence. And one thing that you find in common among the many articles and speeches is talking about the need for public education. The reality is that we do a terrible job of civics education in this country, that most people don't have an appreciation for the importance of an independent judiciary. And the more there is rhetoric attacking the judiciary, the more it's made to seem that judges should just do what the politicians want, the more we undermine the public understanding that's essential. And yet, as much as everyone talks about the need for public education, no one has figured out how to do so effectively here. As we talk about judicial independence today, we have to realize that that is an expression does not resonate with people. It is just too abstract. Let me give you an example. A few years ago in California, a very respected state Superior Court judge, Erwin Chemerinsky, had to handle a difficult sexual assault case. It involved two teenagers, both of whom were very drunk at the time. Judge Persky found that the defendant, the man, was guilty of sexual assault. He imposed a sentence which was exactly within the range recommended by the probation department. But they got targeted in a viral campaign. The campaign was not only ugly, but it was inaccurate. In the campaign, Judge Persky was attacked for rulings where he wasn't even the judge in the case. The defense of Judge Persky was very much about judicial independence. No judge had been recalled from the bench in California since the early 1930s. I was trying to explain to people, if judges have to fear being recalled, then they're going to be much less likely to just follow the law and the facts. Decisional independence will be compromised. I went and participated in many forums and debates on behalf of Judge Persky. I tried very much to explain the importance of the concept of judicial independence. 60% of the voters cast their ballots to recall Judge Persky and remove him from the bench. The appeal to judicial independence just didn't resonate. I've seen that many other times in California and in other states. In 1986, 3 justices on the California Supreme Court were targeted when they were seeking retention elections. What happened here was the insurance industry, which was sad about their pro-plaintiff rulings, funded a campaign and focused on their death penalty rulings. The defense of these 3 justices, Rose Bird, Cruz Reynoso, Joseph Grodin, was on judicial independence and not wanting judges, when they decide cases, to worry about, are they going to lose a retention election? All 3 of them were denied retention. We can talk about Penny White, who served with great distinction on the Tennessee Supreme Court. She was in a 4-to-1 majority to reverse a death sentence. She didn't write the opinion. Nonetheless, when she came up for re-election, a campaign focused against her, very much about this case, and she was voted off the bench. We can talk about the justices on the Iowa Supreme Court. The Iowa Supreme Court unanimously struck down the state law prohibiting same-sex marriage before the United States Supreme Court decision in Obergefell v. Hodges. At the next election, 3 of the 5 justices, remember it was unanimous, were voted off the bench. The appeal to judicial independence isn't working. So I think the burden on us as judges, as law professors, as lawyers, as law students, is to find a better way to explain to people why it's so essential that we have decisional institutional independence, a better way of explaining and justifying this concept. Second, we need to do a better job of protecting our judges. Thankfully, last year, the federal government significantly increased the protection for federal judges, but I still don't think that it goes far enough. And state judges, even when they hand down unpopular rulings, often receive no protection whatsoever. The protection for judges is essential. How are people going to take on these essential positions? They have to fear safety, themselves and their families. We need to aggressively prosecute those who threaten judges, making sure that those who threaten judges face serious consequences. And this includes not just threats of violence, but those who illegally dox judges, those who illegally swat judges, need to face serious consequences. The criminal law exists in part to send a message, and the message has to be that this is intolerable behavior. Third, we need to change the way in which we talk about the judiciary and how we respond to attacks on the judiciary. I think that there should be nonpartisan condemnation of the kind of rhetoric that we've heard in discussing the federal judiciary, including in the last week. Judges are not politicians in robes. It's certainly appropriate to criticize any judge's ruling. I spent much of my professional career criticizing judges' rulings. But there's also a difference between disagreement on the merits and personal attacks. Calling judges lunatics or unpatriotic should have no role in the rhetoric of our democracy. We also need to come up with better ways of responding to attacks on judges. You might know that just this month, the United States Judicial Conference, its Committee on Judicial Code, is changing the rules so that federal judges can respond to unjustified attacks. I think it's important that there be responses. I'm sympathetic to the rule, though I'm skeptical that the best response to an attack on a judge is going to be the judge's own response. I think this is a place where the bar needs to play the crucial function in responding to attacks on the judiciary. Here I would commend what South Carolina has done in its Commission on Judicial Independence and Impartiality. And its documents clearly say that part of its role is to respond to the attacks on the judiciary. I think when there are inappropriate attacks on judges and judicial rulings, it's the responsibility of the organized bar to speak out, to explain why the rhetoric is inappropriate. I'm discouraged that in the last week, following the unprecedented attacks by the president on the Supreme Court, the bar associations, nationally and locally, have largely been silent. I think that professors and deans need to be a large voice here for the importance of judicial independence. I think also that we're going to need in the longer term, as I've already argued to you, to focus on how to change state judicial elections, to lessen the corrosive effects of money, to make it that judges no longer, when they go on the bench, are looking at the very people they're trying to raise money from. These are just some suggestions of things that I think are imperative to protecting judicial independence. I believe, as I said at the beginning, that our country, our democracy, is at a pivotal moment. I believe that all of us will be judged 5, 10, 25, 50 years from now for what we did at this moment. I've done a lot of reading about the McCarthy era and how we judge what people did then. We likewise will be judged. Will we be praised for what we did to stand up for the rule of law, for enforcing the guardrails of democracy, for preserving judicial independence? Or will we be justifiably condemned for our silence and for our capitulation? At the end of the Constitutional Convention, Benjamin Franklin is supposed to remark, quote, "A republic if you can keep it." I believe if we are going to keep our republic, it will be because of the guardrails of democracy. And at this moment, our guardrails, in fact, throughout American history, our guardrails have been an independent judiciary. So it's our burden to keep the republic. It never has been more important than at this moment. Thank you so much.